It is Tuesday, June 20th, and we have new documents in the IDAHO 4 case. Let's go ahead and start going over them. Hey guys, this is Jules with True Crime Reactions. I just got home and realized that there was quite a few documents posted on the official case of interest site for this IDAHO 4 case. Now, the posting date was actually on the 16th, which was Friday, but I've checked this thing pretty much like 8 times today, and they are just now showing up for me. I don't know why they're showing up on Tuesday whenever they were actually posted for release on the 16th, but whatever. They actually give some detailed information. Now, this main one that we're going to go over in this video is 33 pages long. So I'm not going to read you every little detail of this document, but I noticed while skimming through it that it has a lot of information about how all of the genealogical DNA testing was done. And that has been such a huge topic of discussion in this case. Even though we're not going to go through the entire document right now, I wanted to get these details out. So let's go ahead and get into this first one. Comes now the state of Idaho by and through the Latell County prosecuting attorney and respectfully moves the court for a protective order pursuant to ICR 16-1 for information related to investigative genetic genealogy. This case arises from a quadruple homicide. Law enforcement found the DNA of a potential suspect at the crime scene, and the FBI submitted the DNA to one or more publicly available genetic genealogy services to determine potential relatives of the suspect. One or more. Like, shouldn't they know exactly how many? Why is it one or more? I don't understand why that's not specific, but okay. The FBI then used common genealogical techniques to develop a family tree leading to defendant. The state seeks to protect from disclosure the names and personal information of the hundreds of innocent relatives on the family tree, the name of the publicly available genetic genealogy services used, and certain other information described below. The disclosure of this information is not required by Rule 16 of the Idaho Criminal Rules and should be protected from disclosure for the good cause described below, including the state's privilege to protect the identity of informers as described in Idaho Rule of Evidence 509. On November 13th, 2022, law enforcement found the bodies of Madison Mogan, Kaylee Gonzalez, Xander Kernodle, and Ethan Chapin at 1122 King Road in Moscow, Idaho. All 4 victims died from apparent knife wounds. Law enforcement found a K-bar knife sheath on a bed next to the bodies of Madison and Kaylee. The sheath was face down and partially under both Madison's body and the comforter on the bed. So I'm going to assume that her body was on top of the comforter, or maybe she was covered up with the comforter. Law enforcement seized the K-bar knife sheath pursuant to a search warrant. The Idaho State Police Lab in Meridian, Idaho, located DNA on the K-bar knife sheath. The ISP laboratory determined the DNA came from a single source, and that source was male. Once law enforcement had single-source DNA from the K-bar knife sheath, they conducted what is called a short tandem repeat, STR, analysis. STR DNA analysis involves looking at 20 regions within human DNA and allows law enforcement to make a direct comparison between 2 STR DNA profiles. Law enforcement submitted the STR DNA profile obtained from the K-bar knife sheath to the Combined DNA Index System, CODIS, a database of STR DNA profiles from convicted offenders, arrestees, and crime scene evidence to identify the source of the DNA. No match was found. Unable to find a match using STR DNA analysis, law enforcement decided to use investigative genetic genealogy to find a lead. Genetic genealogy allows individuals to trace their lineage or connect with unknown family members using DNA. Typically, it involves sending a DNA sample, such as a tube of saliva, to a genetic genealogy service like Ancestry.com or 23andMe. The genetic genealogy service then creates a single nucleotide polymorphism, SNP, profile to use for genealogical purposes. An SNP profile is different than an strDNA profile and is used more often for genealogical purposes. The genetic genealogy service then uses an algorithm to compare the user's SNP profile to SNP profiles submitted to the genetic genealogy service by other users to determine ancestry and potential relatives. The genetic genealogy service shares with the user a list of potential relatives and, depending on the specific genetic genealogy service, personally identifying information on those individuals like their name, email address, and the amount of DNA the user shares with the potential relatives. The user does not receive any genetic information pertaining to other database users, i.e., users' DNA profiles are not shared with each other, meaning Ancestry.com and 23andMe do not share each other's information. So if you have a whole bunch of family members that have only done 23andMe and you're the only one that's ever done Ancestry.com, those two family trees will never link together, is basically what that means. The same process, used frequently by members of the public, can also be used by law enforcement as part of their investigation, a technique referred to as investigative genetic genealogy, or IgG. Once a publicly available genetic genealogy service shows law enforcement potential relatives of the suspect, law enforcement applies traditional investigative and genealogical methods to build a family tree in an effort to follow the tree to the suspect or a close relative of the suspect. Family trees can be used to narrow down a potential suspect based on factors such as age, gender, opportunity, known physical characteristics of the suspect, etc. In this case, specific to this case, investigators used IgG to begin the process of developing a lead to the individual who left DNA on the K-bar knife sheath. The Idaho State Police utilized a private laboratory to develop a SNP profile from the DNA on the K-bar knife sheath. The private laboratory started using genetic genealogy to develop a family tree, but after law enforcement decided the FBI would take over, the private laboratory ceased its efforts and sent the SNP profile to the FBI. So does this mean that Idaho State Police actually possibly did send the information over to the Othram Labs in Texas, but that once they decided the FBI was going to take over, Othram Labs stopped what they were doing and just sent all of the information over to the FBI? The FBI uploaded the SNP profile to one or more publicly available genetic genealogy services to identify possible family members of the suspect based on shared genetic data. And there we are again. One or more publicly available genetic. Was it one? Was it two? Was it 10? I don't understand why this isn't a more specific statement. The FBI could then view the Genetic Genealogy Service's portal information regarding potential relatives of the suspect who left DNA on the K-bar knife sheath. Based on information the FBI could see in the Genetic Genealogy Service's portal, the FBI went to work building family trees of the genetic relatives to the suspect DNA left at the crime scene in an attempt to identify the contributor of the unknown DNA. The FBI built the family tree using the same tools and methods used by members of the public who wish to learn more about their ancestors. For example, the FBI consulted social media, viewed vital records such as birth and death certificates, and viewed other information already contained in the user portal for the Genetic Genealogy Service, including unverified information submitted by other users of the Genetic Genealogy Service. The FBI also consulted subscription-based databases available to law enforcement for information on the individual people. The product of the genealogy conducted by the FBI was a family tree that contained the name, birth date, and death date, if applicable, of hundreds of relatives, as well as their familial connections between each other and the suspect Bryan C. Kohberger. The FBI then sent a local law enforcement a tip to investigate the defendant. So the FBI are the actual ones, according to this, that did all of the genealogical testing that sent them to Bryan Kohberger. The IGG process pointed law enforcement towards defendant, but it did not provide law enforcement with substantive evidence of guilt. The FBI did not, for example, conduct a direct comparison between the SNP profile from the K-bar knife sheath and defendant's SNP profile. That type of direct comparison required the more traditional STR DNA analysis, which was conducted by the Idaho State Police, not the FBI. FBI did not test the K-bar knife sheath SNP profile directly to Bryan Kohberger's SNP profile. Interesting. Prior to the FBI's IGG efforts, the SPI laboratory developed the traditional STR DNA profile from the DNA found on the K-bar's knife sheath. After identification of defendant, law enforcement recovered trash from the home of defendant's parents, and ISP laboratory did STR DNA analysis of items from the trash for comparison to the unknown crime scene DNA. That comparison indicated the DNA found on the trash belonged to the biological father of the individual who left the DNA on the K-bar knife sheath. Pursuant to a search warrant, law enforcement then collected DNA from defendant. A traditional STR DNA comparison was done between the STR profile found on the K-bar knife sheath and the defendant's DNA. Okay, that's what I wanted to see. The comparison showed a statistical match. Specifically, the STR profile is at least 5.37 octillion times more likely to be seen if defendant is the source than if an unrelated individual randomly selected from the general population is the source. Which this just means that Bryan's DNA is 5.3 octillion times more likely to be the match to the sheath DNA than basically anybody else alive. Basically. The genealogy conducted by the FBI resulted in a lead that pointed law enforcement to defendant, but it did not result in the creation of many documents or records. What? Much of the information relied on by the FBI was only viewed through the user portal in the publicly available genetic genealogy services and other investigative databases. The FBI did not download or create copies of those records. What? So, okay, back up. So they're telling us that all of this crap that I just read to you guys that took me like, at this point, we're at like 17:45, okay, recording time in. All of this crap that I just read to you over 3 pages, and they did it 4 pages, practically. 5 pages? And not many documents or records? All of this testing and all these more than one most likely places that was looked into, and hardly any paperwork? Oh, nope, paper trails, proof or nothing, I don't care. And all this crap about, oh, it was in a user portal. Okay, you couldn't have screenshotted it. You couldn't have made a print screen and copied it and put it into the file. This is all information that you used to put this man in jail. I don't understand this. Okay, once defendant was in custody, the FBI removed the SNP profile from the genetic genealogy services pursuant to the United States Department of Justice interim policy for forensic genetic genealogy, DNA analysis, and searching. The DOJ policy. Okay, so this is a Department of Justice policy, which means that once their tests are concluded and they have their results, then they basically have their access revoked, and the profile that they need matched gets removed from the system of matching, and it's no longer there for anybody else's profile to match to. This means the FBI no longer has access to view much of the information it used to create the family tree and cannot view it again without resubmitting the SNP profile to the genetic genealogy services. To the state's knowledge, The only records that reflect the FBI's efforts to create defendant's family tree is the family tree itself, notes jotted down by FBI agents as they constructed the family tree, and any records created to document the removal of the SNP profile from the genetic genealogy services pursuant to the DOJ policy. The state has not seen, nor does the state possess these records or copy of these records. The state is prosecuting a man and then they don't even have the actual paperwork for the genealogical testing that got them on him in the first place. Okay, I know I'm yelling, and I know people are going to say, oh, there, she's just mad again, because obviously I'm mad a lot in these videos. But are y'all kidding me right now? They are telling us right here in these documents that the state does not even have any of the damn documentation for the genetic testing that linked him to the sheath. That is why they want the genealogical testing to be motion of limine, to be removed as admissible evidence, because they don't physically even have it. You guys are reading this the same way I'm reading it, right? Like, am I losing my shit, or am I really reading it this way? I am not surprised, but surprised at the same time. The state seeks a protective order for a narrow category of information. Yeah, narrow, you meaning non-existent. Namely, information related to the use of IGG in this case. What use? You didn't document anything that you did to have it actually in the case file. You can't even say that y'all actually did any of this right now. If a defendant believes he should receive information that does not fall within one of these discrete Rule 16 categories, the rule allows the defendant to seek an order from the court for information where the defendant can show a substantial need for the information in the preparation of his case. Hello? Hello? You just said you don't even have the paperwork that pointed you in the direction that y'all are now claiming y'all went for reasons you can't prove to us anymore. Are you serious? Are you serious? Here, defendant served on the state a request for discovery that calls for the IGG information, even though the IGG information falls outside of Rule 16, without first obtaining an order from this court. The state now seeks, and the court should enter, an order protecting the information related to the use of IGG in this case. Specifically, the state seeks to protect the following information: the raw data related to the SNP profile and the underlying laboratory documentation related to the development of the profile, such as chain of custody forms, laboratory standard operating procedures, analyst notes, etc. All information related to IGG efforts in creating a family tree and identifying defendants' potential relatives, including the identities of the genetic genealogy services and the personally identifying information of relatives. Okay, but you guys don't have this to protect it. Like, that's what I'm understanding from this. All of this up here, okay, this bull crap about, okay, no documentation. All of this was done, but did not result in the creation of many documents or records. So what documents could you possibly be needing to be protected? You just said that you deleted the raw data of the profile from the genealogy portals. But what underlying laboratory documentation? You just basically said there wasn't any. I don't understand. Okay. The state does not seek to protect and has or will disclose the following information: a genotype kit report from the private lab utilized by the Idaho State Police, which documents that a DNA test was performed. Okay, so that would mean probably Othram Labs. They are not going to protect any information that came from the private lab, which we are just going to assume, based off of 1,000 different rumors, is the Othram Labs in Texas. Information related to the STR DNA analysis conducted using the DNA recovered from the K-bar knife sheath and the DNA recovered from the defendant's parents' trash, which we already knew that whenever they were talking about excluding genealogical DNA, they were not talking about the Pennsylvania trash DNA. Information related to the STR DNA analysis conducted using the DNA recovered from the K-bar sheath and recovered from defendant's swab. So, it makes sense that they are totally okay with the trash DNA analysis coming into court, and they're totally okay with the actual DNA of Bryan being compared to the knife sheath. But you cannot have an arrest that was given to you by someone else's tip based off of information that they did that is also conducting investigations in this case, aka the FBI led Moscow police to Bryan Kohberger, and not have the information that led you there. Because even if Bryan Kohberger is their guy, stuff like this, technicalities and crap like this, does not look good for there being an actual conviction. Stuff like this, bullshittery and games like this can get a guilty man back off and into the public, okay? I do not like this. I do not like this. I do not like this just based on the fact that they literally put a man in jail and are telling us right now in black and white that all of the documentation and all of the records that they should be producing to show proof of what got them to Bryan Kohberger, they don't really have it. So they're just going to say that they want to protect it because they really in reality just don't have it. I am just, wow. Okay. Rule 16 does not require the disclosure of IGG information because the IGG information is not exculpatory. Rule 16 of the Idaho Criminal Rule does not require the disclosure of the IGG information because the IGG information does not tend to negate the guilt or reduce the potential punishment of the defendant. Okay, but if you can't even produce how you got to your conclusion of that, then how are we supposed to trust it? How are we supposed to trust it? How is the defense supposed to trust this testing if they are seeing literally no physical proof of it besides the end result? That's not how this is supposed to work. The rule requires the state to disclose any material or information in the prosecuting attorney's possession or control, but you don't have it. You literally just told us you don't even have possession of any of the documentation that the defense is actually very specifically asking for, okay? That tends to negate the guilt of the accused as of the offense charged, or that would tend to reduce the punishment of the offense. Now, they are mentioning this Michael Green case, and there is a lot of documentation on it attached to this. I'm not going to go through all of it right now because the basis actually seems to just be right here in this paragraph. And unless I find something more specific about this Michael Green case that I want to talk about, it's probably not going to go farther because the state just told us they don't even have any documentation. So honestly, whatever they're trying to reference doesn't mean shit to me at all at this point. But let's go ahead and read what they're trying to say right here. In Green, law enforcement used DNA recovered from the victim's nightgown to identify the defendant as a possible suspect. Then they surreptitiously recovered items from the defendant's garbage that contained DNA and found through STR DNA testing that the DNA in the defendant's garbage matched the DNA found on the victim's nightgown. Well, that's a little different, because that's basically claiming that the DNA in the garbage was the suspect's garbage straight up, not a paternal match. That's a little different. First, the IGG information is not material to the preparation of the defense. Defendant is charged with killing 4 people, not with being related to a particular person. Really? They're just going to be straight up smart ass about this. Okay. The mere fact that uploading the completed SNP profile into a publicly available genetic genealogy service led law enforcement to relatives of defendant does not affect the strength of the evidence against him. The strength of the evidence against defendant in terms of DNA evidence depends on the confirmatory results of the STR DNA analysis between defendant's DNA profile and the DNA recovered from the K-bar knife sheath. Is this the state admitting to the public that this is literally the only DNA evidence that they have? The strength of the evidence against defendant in terms of DNA evidence depends on the confirmatory result from the STR DNA analysis between the defendant's DNA profile and the DNA recovered from the K-bar knife sheath. Is that them literally telling us that that is the only DNA evidence they have against Bryan Kohberger? Is it? Please let me know how you guys just interpreted that statement. As explained further below, the state intends to introduce the STR DNA analysis at trial and does not intend to enter any evidence pertaining to the development of a SNP profile. So they want to introduce the analysis that was done, but they don't want to give information about how they developed the profile in which the analysis was done on. The immateriality of the IgG information to the preparation of the defense is perhaps best understood by way of analogy. The tip that came from the IgG process, which means the tip that the FBI got from doing their own testing and then sending the tip over to Moscow, is no different than other types of technology hits that put law enforcement on the trail of a suspect. For example, in Johnson, the law enforcement recovered a suspect DNA from a ball cap left at the scene of the bank robbery. Okay, for one, if you have DNA from a ball cap, you have hair follicles, you have skin cells, and you have sweat, baby. You don't just have a little bit of touch DNA. So why they're even trying to compare that to this, I don't even understand. And I'm not even reading it anymore because every example that they're giving me does not match this scenario. This is absolutely stupid. Moreover, the IgG information could not support an argument from defendant that law enforcement violated his Fourth Amendment rights by entering the DNA collected from the K-bar knife sheath into a genetic genealogy service. A defendant cannot prove a violation of the Fourth Amendment without first showing he or she had a reasonable expectation of privacy in the place searched. So, meaning that he can't claim that his Fourth Amendment rights were affected in any way because he didn't personally have his privacy violated, because he didn't personally have his own profile uploaded. Okay, but remember, we heard that rumor that Bryan Kohberger apparently told a neighbor of his at WSU's little step-toe apartments he lived in that he had recently done a genealogical test type thing, ancestry type thing online. So maybe, no, you know what? I'm not even going to maybe nothing because I don't know. The K-bar knife sheath was abandoned at the scene, as was the DNA inside it. Inside it? I thought it was on the snap, not inside of the sheath itself. That would mean to me that it's in the little cubby where the knife goes, and that's not how they worded it, so they better be careful. Defendant cannot show that he had a reasonable expectation of privacy in DNA left at the scene of a quadruple homicide, or in the genetic information of his relatives who voluntarily provided their own DNA to a genetic genealogy service. And now see right here, they're going on to reference some other case, but it's talking about DNA from a water bottle. Okay, that's spit. That is spit. That is not touch DNA. When you guys, I'm telling you right now, just go to Google and look up the differences when it comes to the types of DNA, when it comes to how relevant and accurate and valid they are when it comes to a criminal evidence. Okay, touch DNA is, like I've mentioned before, the court jester in the hierarchy of DNA analysis. And they're literally giving us information and relating cases to this case that have actual substantial DNA evidence in them from actual substantial DNA sources, not touch DNA. They need to dig a little bit deeper. Additionally, the sheath and defendant's DNA left on the sheath were seized pursuant to a valid search warrant issued by a magistrate judge, which means the law presumes that the search was reasonable. When a search is conducted pursuant to a warrant, the burden of proof is on the defendant to show that the search was invalid. Second, the state did not rely on the IgG information to establish probable cause. I told you, they knew from the beginning. This wording right here is proof. There was conversations had between FBI and Moscow PD and Don Daniels prior to those arrest and search warrants being signed. Did not present the IgG information to the grand jury. Well, I guess that actually makes sense. And has no plans to present the IgG information for which a protective order is sought as evidence at trial. Instead, the state has relied on and will continue to rely on the STR-DNA analysis comparing defendant's DNA to the DNA on the K-bar knife sheath to establish defendant's guilt. To the extent the DNA on the K-bar knife sheath once belonged to defendant, he abandoned that DNA when he left it at the crime scene of a quadruple homicide. In short, none of the IgG information the state seeks to protect came directly from defendant or currently belongs to defendant, and thus Rule 16b-4 does not require its disclosure. I'm still claiming that the only reason they don't want to give any information over whatsoever is because they literally don't have the information. If they had the actual information and it really showed everything that they're telling us, why wouldn't they add it in there? Why wouldn't it be in there as just another bullet to their smoking gun? Why not just load the whole clip if you can? I don't quite understand that. Then it says, C, Rule 16 also requires the disclosure of information related to scientific experiments, but it only applies to limited information. Namely, Rule 16 requires the disclosure of results or reports of scientific tests or experiments made in connection with the particular case. Which means that them basically only having the results from the familial genetic DNA testing is all that's technically required. Who wrote these rules? Jeez. The rule does not require the state to disclose what law enforcement does with the results or reports. What? Okay. Moreover, a process, procedure, or investigative technique is not a scientific test or experiment merely because it involves the comparison of information or objects or requires the use of logic or reason. Okay, but it is a scientific test. It's literally called testing. There were two types of scientific tests conducted with respect to DNA that fall within the purview of Rule 16b-5. First, law enforcement used STR-DNA analysis to compare the DNA on the K-bar knife sheath to the defendant's father and then to the defendant. As required by Rule 16b-5, the state has provided the reports from those scientific tests. The state also provided other information related to the STR-DNA analysis because the state plans on using that information at trial. Okay, so yeah. Second, the private laboratory developed the S&P profile from the DNA on the K-bar sheath. As required by rule, the state will produce the reports that documents that DNA test. So like I mentioned already, because this is starting to repeat itself, this is most likely going to be Othram Labs that developed the S&P profile, but then had to stop before any of the further genealogical testing was done, from the way that this all sounds anyway. Rule 16b-5 does not require the state to disclose how the S&P profile was used. Okay, yeah, we already did all this. We already read all this. The product of the FBI's efforts was a family tree comprised of hundreds of defendants' relatives. It's funny how they try to say very small family tree, but now all of a sudden there's hundreds of names. Put simply, the family tree created by the FBI cannot accurately be described as the results or reports of scientific tests or experiments. I'm so tired of this. All these games. Yes, it is. Yes, it is. You tested other people's profile markers against the S&P profile markers, and that's how you got results. That's exactly what you did. The mere fact the IGG information was not fall within Rule 16 is reason enough for this court to enter an order protecting the IGG information. But the state is not seeking the protection of the IGG information as an exercise in obstinance. Instead, the state seeks to protect hundreds of innocent civilians from having their personal information, including their names, birthdays, and familial connections to the defendant in a high-profile quadruple homicide, from being disclosed. The disclosure of the IGG information risks harm not only to these indirect informants, but also to the genetic genealogy services used by the FBI and the IGG investigative technique. This court should follow the procedure laid out by Idaho's appellate courts to determine whether the IGG information must be disclosed. Okay, let me just skim through and see if there's anything that's basically not them just repeating themselves for the fifth time. Okay, conclusion. Based on the above, the state respectfully prays for the court to enter an order protecting the IGG information from disclosure as it follows, blah, 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 blah. Yeah, okay. And then this is where it gets into all those documentations for the Michael Green case. Well, that is it for this document. I will take a look at the rest of the documents that were posted and most likely do a video on those tomorrow if there's anything important in them. If there's nothing too special, then I'll just post screenshots of the documents in my community tab. But I'm glad that we got some more details about the knife sheath itself. But it's also not surprising to me that we're finding out that they literally have no documentation or records from their own words. They possess nothing of the genealogical testing that was done when it came to how they actually found Bryan Kohberger's name connected to the genealogy that was connected to the knife sheath DNA. And that's a big problem for me. That should be a big problem for everyone. This is just more proof to me that they knew way ahead of time that the way that they got this information wasn't going to be admissible in court, so they were going to have to cover their bases one way or another. And yes, I do understand that they obviously do now have Bryan's DNA directly tested to the knife sheath, which is what needed to be done anyway. But these kind of issues are the kind of issues that I talked about in my other video. Things like this, problems like this that could be fought by the defense could possibly get a guilty man on the streets. But the same kind of things being just let go and just not cared about in front of a judge can also put an innocent man in front of a firing squad. So these things are important, and it's just so insane to me that now they're just coming out and they're having to admit it. But I'm going to go ahead and get this edited up and posted. And like I mentioned, I'll go through the rest of the documents probably tomorrow. So I guess until then, see y'all.